All right, everybody. Good evening, friends, and thank you for being with us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law Federalist Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of our Constitution. Our resolution tonight is: should judges embrace natural law principles? This is a debate of remarkable importance to our great American experiment, and we are humbled to have such blockbuster speakers to fight it out. To lead us off tonight, we have the man I consider the father of modern natural law and a living legend, Professor Hadley Arcus of the James Wilson Institute.
Your living legend.
Walk in the room.
To meet his challenge, we're thrilled to have the fearless champion of originalism, Professor Lee Strang, Executive Director of the newly founded Salmon P. Chase Center for Civics, Culture, and Society at the Ohio State University Morris School of Law. We are also deeply honored to host the Honorable Judge Mady of the United States Court of Appeals for the Third Circuit, a beacon of courage and legal brilliance, as our esteemed moderator. We are deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster Debate Series a reality. I now recognize our excellent Director of Debates, Ian Stapleton, to introduce these three stellar panelists. Please give them a warm welcome.
The Honorable Paul V. Mady serves as a judge on the United States Court of Appeals for the Third Circuit. Before his judicial service, Judge Mady was a partner at Lowenstein Sandler in New Jersey. And before that, he was the Senior Vice President, General Counsel, and Secretary for University Hospital Newark. He also served as the Deputy Chief Counsel to Governor Chris Christie and as an Assistant United States Attorney in the District of New Jersey, where he was awarded the Justice Department's Director Award for Superior Performance. He also practiced at the Washington, D.C. firm of Kellogg, Hanson, Todd, Feigl, and Frederick, and served as a law clerk to judges on the Third Circuit and the District of New Jersey. He earned his bachelor's degree from the University of Scranton and his JD, summa cum laude, from Seton Hall University School of Law, where he served as editor-in-chief of the Seton Hall Law Review. Professor Hadley P. Arcus, in addition to being a living legend, has been a member of the Amherst College faculty since 1966, and since 1987, he has been the Edward Ney Professor of Jurisprudence. Since 2016, he has assumed emeritus status. He has written numerous scholarly works, both books and articles, as some members in the audience have brought with them today, with some of his articles having appeared in professional journals. Professor Arcus has been the founder at Amherst of the Committee for the American Founding, a group of alumni and students seeking to preserve at Amherst the doctrines of natural rights taught by the American founders and President Lincoln. That interest has been carried over now to the founding of a new center for the jurisprudence of natural law in Washington, D.C., the James Wilson Institute on Natural Rights and the American Founding, named for one of the premier minds among the American founders, and a favorite here at the Federalist Society. No surprise there. Professor Lee J. Strang is professor of law at as we know, Ohio State University Moritz College of Law, where he is also the inaugural executive director of the Salmon P. Chase Center for Civics, Culture, and Society. A nationally recognized legal scholar, Professor Strang has published dozens of articles in the fields of constitutional law and interpretation, property law, and religion and the First Amendment. Prior to joining Ohio State, Professor Strang served as the John W. Stopler Professor of Law and Values and Director of the Institute of American Constitutional Thought and Leadership at the University of Toledo. He was previously a visiting scholar at the James Madison Program at Princeton University and the Georgetown Center for the Constitution. Prior to teaching, Professor Strang served as a law clerk for Judge Alice M. Batchelder of the Sixth Circuit. He was also an associate for Jenner and Block LLP in Chicago, where he practiced in general and appellate litigation. So without further ado, I hand it over to our moderator to introduce the subject. If we could give all of our wonderful panelists another round of applause.
Well, thanks for that
kind and superlative-laden introduction. It is an honor to join living legends and nationally renowned scholars. I am merely a humble student of these gentlemen.
I'm
I
just
wanna-
a country lawyer.
I'm gonna take my pocket watch out. First, I want to thank the Georgetown University Law Center's Federal Society chapter, as well as the Federal Society for Law and Public Policy Studies for preparing, organizing, and executing this exceptional series of debates. Special credit goes out to the student chapter, who has won not one, but 2 awards this year for their extraordinary original programming. So congratulations to you for launching this consequential series of debates. I want to thank my panelists this evening. I do not exaggerate when I say I have learned much from their works, both of which are foundational, informative on the subject that we consider tonight. If you have not already, read them. You are busy, have much to consider as law students, but there is always ample time for the ideas that matter. And the works of Professor Strang and Professor Arcus are among the most fundamental and consequential to the debates that we consider tonight. And that debate centers on a simple question: what is law? What is the American legal tradition? For some 4 decades, the answer to that question has come from the tools given to us by the theories of legal positivism. The idea that words are the source of meaning, and that, when properly or ordinarily understood as a reasonable, competent speaker would. Originalism and textualism provide a firm foundation for predictable and sustainable decisions. It is a period of positivism realized. But there was an earlier time, a time when, as the great jurist and theorist William Blackstone observed, an appropriate historical inquiry cannot be conducted while remaining blind to the reason, spirit of the law that provides for its validity and for its natural purpose. It was, in other words, an error of judging under tradition and not merely rules. Have we departed from that principle? And are we overextending the conditional authority that judges enjoy? Authority that depends on the assumption that our work would complement, not clash against what Alexander Hamilton once explained: good and wise men in all ages have supposed that the deity, from the relations we stand in to himself and to each other, has constituted an eternal and immutable law which is indispensably obligatory upon all mankind. And that promise was seemingly reflected in the Constitution's promise of a government ordained to provide for the general welfare, secure the blessings of liberty. For Hamilton, again, natural liberty is the gift of a beneficent creator, while civil liberty is only natural liberty modified and secured by the sanctions of civil society. So we ask tonight, should judges employ natural law principles? Or perhaps better, as some judges have argued in opinions, well, at least I have argued in opinions, we must consider the sources that animate the natural rights that are protected in our Constitution. That's 124F fourth and 233 for those who are footnoting along at home. Because if, as Jefferson wrote, the object of declaring our independence was not to find new principles or new arguments never thought of, then how can we, as Hamilton added, overlook these certain primary truths or first principles upon which all subsequent readings must depend? I am but an eager student of these questions, and I am eager to join the discussion led tonight by the 2 outstanding panelists. It is with great privilege I turn it over to them, beginning with Professor Arcus.
Thanks, Mike. Does this work?
Indeed.
Thanks, I think, for that over-the-top introduction. And that reminds me of that cartoon years ago in the New Yorker of a figure, a 19th century guard, pointing out there next to the statue that people are like ants. And on the top it says, soldier, statesman, patriot, author, but still a disappointment to his mother. It's good to see Lee for the first time, not on Zoom, but actually. Let me begin now. A president of Amherst College once said that Hadley has a theory of natural law. And I said, when you say that, you rather suggest you're standing back in wholesome detachment, watching theories whiz past. And somewhere you're able to form a judgment on the strands of those theories that are plausible or implausible, true or false. I said, take me back to the grounds on which you're making those judgments, about the things you reliably know, and you'd be led back to the ground that some of us take to be the ground of the natural law. What I'm suggesting here was picked up by James Wilson, one of our premier minds of the American founders, in the opening lines of that first decision, first case, reprinted in the U.S. reports, Chisholm versus George in 1793. Wilson said, we're at the very beginning of law. We have no distinct precedents to call upon. We have to go back to the general principles of jurisprudence. But before that, we have to go back to the principles of mind, the way we come to know anything reliable. And there he invoked the great Scott philosopher, Thomas Reed, who was read closely by Jefferson and Adams. Jefferson said he wanted to know the Constitutional Convention. Read on natural language. Thomas Reed, with his great teachings on the precepts of common sense, not the instincts of the herd, but those things so fundamental that the average man not only has to know them, but virtually has to take them for granted in getting on with the business of life. They're the things he must know before he can start trafficking in theories. And so before the average man will start bantering with David Hume about the meaning of causation, he knew his own active powers to cause his own acts to happen. He knew that every event had a cause. He also knew in that vein the deepest first principle of all moral and legal judgment, understood by Kant and Aquinas as well as Reed, that it makes no sense to cast judgments of praise or blame on people for things that they were powerless to do, to hold people blameworthy and responsible for acts they were powerless to effect. As Reed said, no axiom of Euclid appears more evident than this. The average person told that Jones, accused of a serious crime, was undergoing surgery at the time the crime was committed, would wonder why he's being prosecuted. The ordinary man gets it. That principle not only explains the insanity defense, but I could show if we had the time, I could find the threads emanating from that principle going through our own law. And I think it finally does come into play in explaining the deep wrong in principle of racial discrimination. As Wilson and Hamilton understood, everything we know, every branch of knowledge, including jurisprudence, must begin with these anchoring axioms or necessary truths. We have to move from things reliably known to things we're trying to know. As Hamilton put in those wonderful lines in the Federalist 31, in dispositions of every kind, there are certain primary truths or first principles upon which all subsequent reasonings must depend. They contain an eternal evidence, which antecedent to all reflection or combination command the assent of the mind. These primary truths are things we grasp per se nota as true in themselves. The two contradictory propositions both cannot be true. And by the way, even that innocent law of contradiction has the effect of delivering, of revealing the vacuity of propositions that even many learned people take seriously, but more of that later. What James Wilson was putting before us was this. It was not a theory that two contradictory propositions both cannot be true. No more was it a theory that it's wrong to hold people blameworthy and responsible for acts they were powerless to effect. And what he's putting before us is this. If I can indeed bring out the ground of a jurisprudence based on axioms of that kind, I'm not offering you a theory. I'm offering you the real thing. That's what I sought to restate in my book, Mere Natural Law. Wilson and Hamilton, the other founders, understood that those principles of axioms, or those principles, were there before the Constitution. They're the things that the founders drew upon as they framed the Constitution, and they knew they would also be there even if there were no Constitution. My dear friend Garrett Cassis, during the first day of the oral argument on Obamacare, invoked John Marshall in the old Dartmouth College case, saying that to impose upon people a contract they did not wish, say, compelling them to buy medical insurance, could be as bad as impairing the obligation of a contract they willingly made. And Justice Story in his commentaries would later say that principle would be true even if there were no constitution. And John Quincy Adams would tell us later that right to petition the government is simply implicit in the idea of a free society. It would be there even if it weren't mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. In my book, Beyond the Constitution, which I know Paul knows, and this man has, I sought to show how the judges were persistently drawn beyond the text of the Constitution to those principles that were there as they tried to explain their judgments. In the old Ullman case on espionage in 1956, the question centered on that passage in the Fifth Amendment. Nor shall any person be compelled in any criminal case to be a witness against himself. And Justice Frankfurter says, we can't take that passage literally. Where's the accent? Is it on criminal, compelled, against himself? If we give this man immunity, can we compel him to testify against his friends in the Communist Party? Or is it on compelled? It's wrong to extract evidence under compulsion. In that case, it may not matter whether it can testify against himself or anyone else. But now let me take it to the sharpest part. A friend of mine, Professor Joel Alicia at Catholic University, says the darndest things. And he remarked in one of his articles that it is widely acknowledged by scholars that the Constitution, as originally understood, did not empower federal judges to set aside positive law in the light of natural law. If so, that would have come as news to James Wilson and John Marshall. And there would be no more dramatic example of this said than Marshall's classic opinion in Fletcher versus Peck in 1810. Some of you may recall, there was a rescission by legislature of a granted lands with a touch of scandal. But the rescission affected innocent buyers of the land. So when it came to the court, it seemed to be applying the matter of a law impairing the obligation of the contract, Article 1, Section 10. But instead of settling the matter on Article 1, Section 10, Marshall did something just far more elegant. He showed how the contrast clause could be drawn deductively to a syllogism from that deeper underlying principle ex post facto laws, making something criminal after the fact that was not criminal what was done. One of the deep principles of law. And when he did this, he was able to say something quite striking. He said, Georgia is a great state. It's part of the American Union. But even if Georgia were a separate state, outside the Union, outside the Constitution, outside Article 1, Section 10, this law would still be wrong because its wrongness was rooted in a proposition that did not depend at all for its validity on being mentioned anywhere in the text of the Constitution. Something Joe Lee should never noticed. Okay. But let's take it right up. We fast forward. Now I'm with my beloved friend Anthony Scalia after the Heller case, where the court judged that the Second Amendment applied not only to militias, but to individuals with a legitimate claim to self-defense. So in the conversation, I said, I assume you were referring to an innocent person fending off an unjustified assault. Exactly right. I said, yeah, but those words are not in the Second Amendment. So let me give you two alternatives where you're saying that James Wilson and William Johnson both are claimed a right to self-defense, and many people read them at the time. If so, you're converting jurisprudence into legislative history. We have to find out how many people who voted and ratified the Second Amendment actually read them. And it will still not be the answer to the question we're asking, which is there in fact a deep principle to establish the right of an innocent person to have access to a lethal weapon, if it were necessary, to his defense? In that case, I said to Scalia, are you then appealing to a principle that does not depend at all for its validity on being mentioned anywhere in the text? And in his candor, he said, I've got to think about that. I've got to think about that. Never had the answer from him, but the answer was finally supplied by Sam Alito. Just a couple of years ago, in the Bruin case on guns, the statute had required people to apply for a license to carry a concealed weapon. The court struck down this law. But Justice Thomas felt obliged to go out of his way to show that a statute of this kind had no recognition of the long history and tradition of our law. But the problem for Justice Thomas is that he kept running into legislation from different states, even Texas and West Virginia, that indeed had laws of that kind, that embarrassed his reading of the historical record. So when the record disclosed these cases that ran counter to his reading, well, they're branded as outliers or decisions not widely adopted in other places. And that was enough to hurt him the derision of historians and blow a telling hole in his argument. With Thomas writing, the court did strike down the law, but the decisive opinion was written by Sam Alito in his concurring opinion. He focused on the principle that governed the case rather than a clutter of historical episodes. He offered what he called a succinct account this way. District of Columbia versus Heller, the court concluded the Second Amendment protects a right to keep a handgun in the home for self-defense. He pointed out that the amendment codified a pre-existing right, something that had existed before the Constitution, and even if there were no Constitution, some natural right of self-defense, he said. Second step, the Heller case simply concerns the possession of a handgun in the home. But as you reminded us, the key point was that we decided was that people, not just members of the militia, have the right to use a firearm to defend themselves, because many people face a serious risk of lethal violence when they venture outside their homes. The Second Amendment was understood at the time to cover circumstances of that kind. So it's reduced to these two propositions, axioms. One, there's a deep natural right to have access to a lethal weapon when it may be necessary to protect the person from unjustified assault in his life. Two, if there is such a right, it could not possibly disappear when a man leaves his home and ventures into an outside world where dangers may happen. That's it. The argument is anchored in necessary truth. There's no morally coherent ground that could possibly deny that second step, which carried the reasoning all the way. All the rest of it, the flashbacks to English history, the case law, American law, was all essentially beside the point. In all strictness, they were radically unnecessary in making one's way to the anchoring truth on which is found the decision finally rested. Alito's opinion was succinct, as he said, clear, comprehensible. Any ordinary person could understand that if he weren't burdened by a degree in law, he was an anchoring moral understanding of the natural law. You may not have noticed that he was doing natural law because it was all just so natural. Thank you.
That's a hard act to follow, especially a living legend.
I just came in to read the meter and ask you over some words.
Thanks, Brady. Thanks, Ian. It's great to be here with Hadley in person, one of the leading scholars of natural law. Judge Mady, a judicious moderator, as we have seen and will see, one of our nation's leading jurists. I think of tonight's debate as being a family affair, that people who share many premises, theological, philosophical, and others,
Right.
And also share citizenship. We're Americans, right? So we're parts of the natural law tradition. We're Americans, and so how does that tradition apply, or best understood to apply, in the American context? I'll make two quick moves in my initial remarks that lay out, I think, distance between Professor Arcus and myself. First, I'll explain that whether, to what degree, and how a person holding judicial office in a particular political community may utilize natural law is what Aquinas called determinatio. That is, the choice within the legal system's reasonable judgment, one that is itself evidenced or must be evidenced by the political community's positive law. Second, I'll argue that our legal system reasonably determined that people like Judge Mady, who hold federal judicial office, should typically follow the Constitution's original meaning. With three instances, I'll argue at the end, just very briefly, I'll note, where federal judges are authorized, I argue in fact required, to employ first order normative principles to decide constitutional cases. I'm not going to directly respond to Hadley's arguments in this, other than I'll have a couple of notes. A lot of things I can't say, of course, in 7 to 10 minutes, so I'm looking forward to your questions and comments. So my first move this evening is to argue that a legal system's judicial office is itself a determination, a choice that each legal system must make. Stepping back, there's a stream in legal thought. I think Hadley is a proponent of this stream. We'll see what he has to say in his rebuttal. What I call the maximalist position. That is, how natural law should operate in constitutional interpretation is that federal judges should employ first order normative reasons in their legally governed conduct. Now, of course, in their personal lives, I'm on board with them using natural law. What we're talking about is the legally governed conduct. But perhaps the most famous example of this was Justice Goldberg's concurrence in Griswold versus Connecticut, where he invoked the Ninth Amendment as a textual hook for relying on unenumerated fundamental rights. And this maximalist view includes the claim that positive law is void if it violates natural law. This is a claim that Professor Arcus has made in his scholarship, and that judges can say so. Very early in the Republic, Justice Chase, so Chisholm versus Georgia was referenced as a data point for Professor Arcus's position. I think Calder versus Bolin, Chase's opinion, can also be another data point. Chase said, I cannot subscribe to the omnipotence of the state legislature or that it is absolute and without control, although its authority should not be expressly restrained by the Constitution. I want to emphasize that this maximalist view, that is, that government officials, especially judges, can rely on their first order normative judgments to conduct their legal duties, can be a reasonable approach if warranted by the circumstances. In fact, that was an aspect of the English common law system, at least during its formative years. The common law system, before it had produced legal norms of sufficient number and breadth and depth to govern most activity, required judges to consult their own first order normative views of what is legal because of the legally underdetermined nature of the legal system at the time, and rule according to those first order normative judgments. However, and here's the key point, I think the key point of difference between us, but we'll see, each legal system must determine, it must make a choice about how best under the circumstances that legal system and its officers shall employ natural law. There's no natural law norm that I'm aware of, Professor Arcus may tell us one, that any particular legal officer wields authority to utilize his or her first order normative judgments. And instead, that's because human beings are typically not born with, nor are officers created with, any necessary legal authority to utilize natural law. Just one caveat, so for those of you who are religious, perhaps you could imagine some particular political communities, I'm here thinking of the Davidic kingdom, that might have natural law authority, or an office that has authority, or for those who are Roman Catholic, you might think of the papacy as having some authority. So putting that off to the side, the United States is neither of those. Instead, political communities choose whether and to what degree each office shall utilize natural law. As explained in a number of works by natural lawyer John Finnis, courts in Western legal systems have characteristics that suit them for the role of following their political community's positive law and not for utilizing natural law. I'll identify just two of these salient characteristics. First, court personnel are trained and have long experience in positive law. Judges like Judge Mady are deeply learned in the law, with practice experience, teaching and research experience, and significant experience in government service. This training and legal experience equips courts for their task of pronouncing positive law, but not for articulating natural law. Second, court procedures, unlike, say, legislative procedures, are not aimed at creating or changing the positive law in response to a prudent weighing of different goods to secure the community's common good. For example, parties before a court argue in their own interests and not the interests of the broader political community. And they present claims about the law was, when the legal system arose, not what the law should be to secure the common good into the future. The existence of these and other reasons to limit judicial office to following just the positive law makes it an open question for each community whether a particular community has authorized its judges to follow only the positive law or also for judges to utilize natural law. Let me turn to the United States. My second move this evening is to argue that our legal system's determination, and I guess I'm in Professor Elisea's company tonight in there, is that federal judges should typically follow originalism and not natural law. As I argue whether and to what degree and how American judges should employ natural law in their decision-making is a determination of our legal system. And to determine what our legal system's determinatio is for federal judges, we must look to our actual positive law. What does it authorize? What does it prohibit? Because of time constraints, I'll offer two related pieces of evidence that our legal system has instructed federal judges to employ the posited Constitution's original meaning and not natural law in the exercise of their official duties. First, and this is a conditional. To the extent that originalism is the correct theory of interpretation, which I understand Professor Arcus is not saying that, but to the extent that you all find persuasive originalism to one degree or another, then it limits federal judges to following the Constitution's original public meaning. This original meaning is a posited human artifact. It's not natural law. So if one's true, then one of the corollaries is that the natural law jurisprudence identified by Professor Arcus is not true. I don't have the time to go into all the reasons articulated by scholars, including Professor Barnett here at Georgetown, over the past 25 years, why originalism is the best way to interpret our Constitution. So let me offer just one relevant aspect to our conversation tonight. Originalism, I've argued, is faithful to the natural law tradition because it treats the Constitution's original meaning as our political community's key positive law means to secure America's common good. And officers swear an oath prescribed in Article 6 to support this Constitution, and by corollary, only this Constitution. And so the only thing that Judge Mady and his colleagues shall follow when they exercise their legal authority is our posited Constitution's original meaning, not natural law. Second, evidence contemporary with the framing ratification shows that our political community created a judicial office that required federal judges to follow the posited Constitution and not natural law. There are a couple points of evidence that I think Professor Arcus in his remarks and in his writings has pointed to. Let me just, here's a very broad brush. The English legal system, from my perspective, following William Blackstone's rules of interpretation, looked at how do we understand the posited norms of Parliament. We looked at, for example, he said the signification of the words in their most common and ordinary meaning. The Federalist Papers explicitly invoked Blackstone's rules of interpretation in the debates over how to interpret the Constitution. The early Republic and the Marshall Court, my view is, for the most part, we'll talk about Fletcher versus Peck in a moment, used this originalist approach to constitutional interpretation. Most of you are familiar with Marbury versus Madison and the famous aphorism, it is emphatically the province and duty of the judicial department to say what the law is. But what's more important for my purposes is the reasoning that Marshall was getting at. And the reasoning was the idea of judicial duty, that there's the supreme law of the land, the Constitution, which is supreme because it was adopted by the American people. Judicial duty requires the following of the law, including the supreme law, and judicial duty requires the following of the Constitution when it conflicts with the statute. That's the judicial duty argument. What's more important for our purposes is that reasoning, and Marshall's reasoning entirely defines judicial duty, not in the scope of natural law norms, but entirely in the scope of posited and authorized positive law norms. And this continued in the later Marshall Court. So a case that I would suggest would be Ogden versus Saunders, in which Chief Justice Marshall again employed the Blackstonian rules of interpretation. And one scholar that I would suggest, I'd like to see what Professor Arcus says, Christopher Wolf's book, The Rise of Modern Judicial Review, I think is still the best book articulating this perspective on the early republic. Now, of course, as Professor Arcus has said, the data isn't univocal, right? I think there are pieces of evidence pointing the other direction. I mentioned Chase's opinion. I actually don't think Fletcher versus Peck supports Professor Arcus's position. Fletcher versus Peck, I think, is ambiguous at best. So you have Marshall's argument where he relies on the contracts clause, and then he says, oh, and by the way, fundamental principles of natural justice will also lead to the same conclusion. And what I would be interested in, is there an opinion by Marshall that says, just based on natural law, here's the conclusion, without treating it, this is my perspective, as an additional normative argument, or maybe one might say is window dressing to the positive law argument. Let me close by noting three situations where our legal system, I think, has instructed federal judges to employ natural law. First, to the extent that the original meaning requires it. So cruel in the Eighth Amendment requires that judges make a decision about whether a punishment is disproportionate to the crime. Second, when the original meaning is underdetermined, it doesn't provide enough information to decide a case, that the relevant legal official then should use natural law. Third, in evaluating the continued viability of non-originalist precedent, one of the criteria that judges should take into account is the licitness, the ethicalness, the justness of that non-originalist precedent. The last comment I'll make is, if any figure is a figure in the natural law tradition, it's Thomas Aquinas. Thomas Aquinas famously has a four-part definition of law. Two parts of the definition, Professor Arcus spent a lot of time on. In fact, I would say all of his time on this evening. But two parts he spent, I think, no time on, which is that a law must be promulgated by him who has care of the community. And when the burden of my argument tonight is to say that the Constitution is our law promulgated by our political community, and that originalism is the tool that helps us understand that promulgated tool that will lead to securing the common good. So looking forward to Professor Arcus's response. We'll see if I'm right that he's in the maximalist stream, and if he has other evidence that during the framing ratification period, natural law was employed for constitutional interpretation. Thank you.
All right, the court has many questions this evening, but we will allow brief rebuttal from litigants before turning to the inquiry. So, Professor.
Okay, first of all, I spent my life teaching the American founding, thinking that the best was something to be revered, something to be prized. And you find your best understandings, give us study the people like Hamilton, Madison, who give us the clearest account of what they have done. We are not offering to rejecting originalism. We want the originalism that is connected to the original understanding of the founding, of the moral ground of the founding. You couldn't detach from Marshall the Constitution from the moral ground that established the rightness of government by the conservative government. No man is by nature of other men, the way that God is by nature of the world, men are by nature of horses and dogs. When you cited Marshall, I would think the critical point that was answered by Hamilton in Federal 78, when he said, we work under this rule of construction, that any later statute supersedes an early one. But that's not the construction we work with the Constitution. Because the Constitution coming earlier must be able to override the statute coming later, or else it loses its function as a control on the legislative power. And then Hamilton asked, well, how do we know this? It's not part of the positive law. It's part of the nature and reason of the thing. Lee, that's what I thought Marshall was telling us. I don't think he's simply relying on the positive law. I think he's right on the same understanding. We have there's several strands going here.
Is there a timer here, Judge?
Huh?
We're gonna allow a little bit.
Look, as Jonathan G. now points out, I did a workbook on George Sutherland. George Sutherland's study with Thomas Cooley. Cooley said the 14th Amendment was simply that device by which we bring in the principles of the natural law, all the things that the founders never thought they'd have to write down, like parental rights to govern the medical treatment of their own children. That had to be discovered in the 1920s. Is it not there? And so Open Scalise says it's only substantive due process. Does it really count? Well, our friend Dick Helmholtz says, what about a summons? Somebody targeted for prosecution should be alerted that he's a target. A summons is part of the natural law. You think of a judge filed a case, discovered there was no summons, he doing something contrary to the principle of the Constitution by recognizing it? It was happening all the time. Now, Jonathan G. would note that again, the founders didn't think they had a right in the Constitution, everything they knew. I recall the great Gene Rostow, you remember at my dinner table pointing out, look, here's Hamilton and Madison arguing the Helvetius papers about the powers of Congress versus the president in foreign policy. But if anyone was president at creation, those two were. If they weren't clear what the founding meant, well, maybe there was more of a mystery. And as Gene would point out, so much of the work was done in liquidation by people like Madison and others coming around, and Hamilton and Madison arguing about the National Bank. And Madison finally coming around to say, all right, this was done by political actors, not by judges. Political actors arguing over this matter. And so part of Jonathan G. is so much of the work was not done by judges. But I'll just quote one more thing. I picked up a piece on Alicia and the moral ground of originalism. He suddenly discovered there was none. And yeah, it was a late discovery because people like my dear friends Scalia and Bork did not think there was a moral ground of anything. And I cite this one line from Nino, and that original, he said, what was implausible about original, this is Scalia. Properly, the task requires the consideration of an enormous mass of material. In the case of the Constitution, its amendments, to mention only one element, the records of the false ratifying debates in all the states. Even beyond that, it requires an evaluation of the reliability of that material. Many of the reports of the ratifying debates, for example, I thought unreliable. And further still, it requires immersing oneself in the political and intellectual atmosphere of the time, somehow placing out of mind knowledge that we have in an earlier age, did not putting on beliefs, attitudes, philosophies, prejudices, and loyalties that are not those of our present time. In short, is a task sometime better suited to the historian than the lawyer. He says it's eminently improbable. So why do you do it? Because no alternative commands a consensus. He says, the problem with natural law, it doesn't command a consensus, which his friend said, did you get a consensus on that proposition? Did you take a survey? Because we didn't get our ballots. If we got our ballots, you would have had a consensus. He was simply offering us the old fallacy. If they're all these universal truths, they'd be recognized universally. The fact that they inspire widespread disagreement is prima facie evidence that they're not there, which reduces to the claim the presence of disagreement shows the absence of truth. I record my own disagreement with that proposition, and that's enough to say, that's all Nino had to offer. And
Professor Arcus has now invoked both Justice Scalia and the dinner table.
okay.
Such a record.
The point is, it doesn't require, originalism does not require this truncated positivism that's been offered us in the name of originalism. That's my pitch.
Strong words, Professor. Your rebuttal.
I'll keep her at 2 minutes. So three quick points. So Professor
You can take
Arcus,
3, take 5, go
we
out.
want to get questions. Professor Arcus made the claim that originalism doesn't have a moral grounding. And what I would recommend to you is, I think there are 5 different categories of moral grounding that scholars have offered for the last 25 years. Professor Barnett offered, I think, one of the most powerful ones that often is most attractive to students in his Restoring the Lost Constitution book back in 2000. I have my own. There's a whole natural law school of originalism. So there clearly are people who think they are, and I think are offering plausible arguments for moral grounding. And even the example that Professor Arcus gave in the beginning of his rebuttal, I don't think supports his position. So Professor Arcus was describing, how do we know, for example, that the Constitution, even though it's earlier in time, trumps other legal propositions? And the answer is Article 6, guys, right? So that was something they debated in the Philadelphia Convention. Article 6, Clause 2 says that anything in other laws notwithstanding. So the notwithstanding proposition was something they put in there because it was something that they were worried about. So it's an exact example of what I'm talking about.
What does that leave?
It's the non obstante. So it's Article 6, Clause 2.
Which one? Who's read it?
Anything under the constitutional laws of any state or to the contrary notwithstanding.
It's a supremacy clause.
Yeah, but it's also describing things that regarding time too. So it's a non obstante. So my point is that there was a legal tradition where if as you had said, things that are later in time trump earlier in time, but we have this legal tradition that was directly invoked by the Constitution. So let me finish my part. So even the example that he gave is one that the framers and ratifiers had identified as, we realize this is a phenomenon, we're going to rely on our existing legal tradition incorporated in Article 6. So Professor Arcus makes the claim that if somebody doesn't support his position, that somebody is denying the validity of natural law, because the fallacy, which I agree is a fallacy, that if you have disagreement about a proposition, the proposition doesn't exist. But my position isn't that. My position is that, like many bodies of knowledge, natural law is something that reasonable human beings disagree with. There can be multiple reasons for it. It could be failures on our own part, right? We could have vicious characters, but more likely it's that many of the propositions themselves are hard, or, and here's the more robust claim, which I don't know if you agree with or not, many of the propositions are, in fact, indeterminate, that there's not one right answer. And there's lots of common examples for that. And Professor Arcus, the example that I would use, and all of us have experience with, is highway regulation, right? So highway regulation isn't just one variable, right, which Professor Arcus in some of his writing described safe driving. It is that, but it's so much more, right? We want to have efficient driving. We want to have driving so that we can effectively get to the places that we want to go to get the good of knowledge that we're having tonight. We want to have the good of civic friendship, right? So thinking about the ways in which we interact on the highways, where we interact in a cordial, civil way, as opposed to, I don't know if anybody's ever been to Rome and driven around, as opposed to other ways of driving with other folks. So my point is that the system that we have in the United States required many reason-guided, but not reason-determined decisions. And so acknowledging that there's disagreement about how the natural law plays out in a particular context isn't the same thing as saying there's no natural law, right? And what I'm saying is that maybe most of the Constitution actually is more like highway regulation than it is like principles of non-contradiction. Think of the power of Congress over post roads. I think it's probably a good idea, but I can imagine reasonable people saying, yeah, let a private enterprise do post roads. So my 2 points are that, in fact, Professor Arcus's evidence of natural law being employed by federal judges is thin. And then second, and the reason why it's thin is because there's so much of a need for positive law to effectively pursue the common good in a political community.
All right. So as we established earlier tonight, I'm just a humble country boy. And one of the things, Professor Strang, you mentioned that I wanted to sort of dive back into is you mentioned that the political community equips courts quite consciously with the ability to work within the positive law system as opposed to the natural law system. So is your argument then that is a present choice, or it has always been the case? And if it isn't simply a present choice, could the community simply decide otherwise and say, this is the values or the process that we wish lawyers to pursue? And I'll kind of tack on to that. Are we really confident that lawyers emerge crisply trained to make fully formed positivist arguments, or are they doing something that might be considered something less than rigorous?
Yeah, great questions. So on the point about when has our political community identified my argument, the limited scope of federal judges? If my claim, of course, is that it goes back to 1789. I would say my claim is that it is applied up to today as well. But I think for my claim to be true, and this might be a bad word for Hadley, Hardian perspective on jurisprudence. So the thin Hardian, HLA. Yeah. So
that is a bad word.
Yeah. So
You just get a brown paper wrapper and wrap that one around.
So the Hardian perspective is, when you think about why is the Constitution perceived as being the authoritative legal norm in our political community, it's not because of present day consent, so pushing back against the temporal. It's because Americans today recognize that there is one authority in American history that has promulgated our supreme law. That's the parameters in Philadelphia and the ratifying conventions in the 13 ratification conventions. And so there's a sense in which it's been that way and it continues that way, but it's only because of the continuing recognition that that's the authority that said that the Constitution is our Constitution, as opposed to some other document that Hadley might create that would be normatively superior to our written Constitution. And so I think that's so it's continuing assent to that. There was a point in time, actually, for those of you who've had constitutional law or administrative law in the 1970s, things got super zany. In administrative law, Goldberg versus Kelly, remember that case? That was the one where we had 4 votes for there's a fundamental right to property and government benefits. So there was a period of time where I think sociologically it was breaking down, kind of like the 10 tablets in Rome, or the tablets of Roman law. They ceased to be functionally in existence, but over the last 30 or 40 years, we've kind of come back to sanity. Judges, so I'll say 2 quick things. So one is, when I think about what it is that judges do, especially lower court judges, right, not the Supreme Court justices, your bread and butter is precedent, Supreme Court precedent, Circuit Court precedent, and you're trained for that for 3 years of law school. You do it in practice, et cetera. So I think that if you have a theory of originalist precedent, which originalists do now, then I think if your bread and butter day in and day out is just following the precedent. Now, I think when it comes to Supreme Court justices, that they have the training for precedent, which is still an operative proposition at the Supreme Court level. But when you have a division of labor, when you have a body of scholars who are spending time doing research on the original meaning of the 8th Amendment, for example, or the free exercise clause, you have that division of labor where the scholars and the attorneys can rely on those scholarly debates to come to informed propositions to present to the courts. So I think the judges themselves aren't trained for the original meaning, or other clerks, but they're able to curate and rely on the arguments presented to them.
Professor Arcus, all your arguments aside, positivists.
All my arguments aside. Did you want to dance? What did you want to do? Okay.
The positivists are going to argue, look, this all comes down to predictability, it comes down to restraint, it comes down to competence. Perhaps you are right, natural law versus sounder, deeper reasoning, but it can't possibly hope to constrain judges in a way that is necessary for a stable republic. And then echoing what Professor Strang has now argued, there is a competence problem. If judges are bad enough in history, imagine if they have to work through the material that you have so richly explored. So isn't this just the best way to ensure stability in our shared common interest?
Well, first of all, we are dealing with things, taking mere natural law, taking back to things that ordinary people understand, the people not burdened with a degree in law. If they can understand it, a judge can understand, even though he puts on the robe, he can still understand it the day after. So the one thing that maybe have to be filled in, that the companies we have with Lee, the things I want to further. Yeah, there are restraints on what these people may do, but just as the natural law provides the ground for the authority for the positive law, it also provides the ground that explains why we bar judges from doing certain things. You know, when we recognize the Soviet Union, and it's a matter of conveying to Stalin's government, the assets held by private citizens, Russian nationals in New York. Yeah, we don't do those kinds of things here. But Sutherland recognizes that a decision to recognize a foreign government is bound up with military strategy. And judges can't get into this for a deep reason of the natural law, going back to the revolution, that the safety of the American people cannot be put in the hands of officers, whether Westminster or unelected judges, who bear no direct responsibility for it, for the safety of the American people. That's why the court should not have been fiddling with the Boumediene case and second guessing what the Bush administration was doing in Iraq. Yeah, there are good reasons for restraining the determinatio, but there are reasons, those are natural law reasons that provide the firmest ground. You know, that line you cited from the supremacy clause, you know, Hamilton did that in the Federalist 33. The supremacy clause would be there even if we hadn't made it explicit. It's part of the logic of the whole design. But there's one point, let me come back to one point, because it may be, as Mr. Bennett said to his wife in Pride and Prejudice, you may not have the pleasure of understanding me, my dear. Let's say we understand behind the those signs saying 35 and 65. Immanuel Kant would tell us, before we have a positive law, there's an underlying natural law that tells us one would be justified in restraining the freedom of people to drive. And as a quiet understand, we always have to make a transition to the underlying principle and apply it to the circumstance at hand. 65 on the open highway, 75 miles the road. Okay. Now, we also know that, let's say that by no people should be held blameworthy or responsible for objects for acts they can affect. We don't. The case may be madly variable. We don't know if Smith really was under hypnosis. How disabled was he? The circumstances are madly variable. But Lee, I want to point out here. The natural law does not tell us what the proper speeding limit is. We have to use our deliberation for that. What I want to make here is that the terms may be madly here. We don't know if Smith was under hypnosis. But the one point that will never be contingent and never be uncertain is the principle itself. If we establish that Jones really was incapable of affecting the outcome, that will establish his innocence. That will not change. Okay, we engage in deliberation as we apply these things to the constitutions and speed limits, but the anchoring principle itself will not change. My opinion.
You know, if I were a real judge and not one who just sat around and thought about the meaning of 5 words for 8 weeks at a time, I would at this point in the hearing say, I think it's time to head to the settlement, because I'm hearing close enough that we can get to. Yes, I am hearing.
I think we are in heated disagreement. We are in heated agreement. They and I are in heated agreement.
Followers are part of this point. Can't we get this thing settled? I hear from Professor Strang that natural law hasn't vanished from the interpretive toolkit. In fact, there are instances that you have cited where it is necessary for the judge to consult. I understand Professor Arcus from criticizing reliance on a clutter of historical episodes, but I don't see you deriding the role of historical example at all in the interpretive process.
Of course.
Isn't that alone progress? Because it does seem that when we took the positivist turn in the later part of the 20th century in interpretation, natural law was relegated to the punchline of many jokes. Now it seems as though we're seeing a robust role for it, interpretation. So, why can't we just agree to that and turn the students loose on this to learn it so that we can have the proper method of interpretation that you gentlemen so richly desire? I'm going to leave for a moment while you work this out, and then I'll come back and we'll sign.
But I want to draw Lee out. I think I really agree with, and I want to just further on.
You try, Judge.
This is that's always good.
How about, but you are that ratification was very important to the meaning of the Constitution. Ratification was.
Okay.
And remember why you said that was utterly critical to the originalists and the meaning of the Constitution? Oh, you made the argument, just inviting you to restate your argument.
About why ratification is
Yeah, yeah,
important?
yeah.
So my claim earlier in response to Judge May's question was that why is it that we look to the Constitution's original meaning as opposed to some meaning later, or could Americans change? And I think the answer is, so long as Americans today recognize that the authority that gave us the Constitution was the primary ratification, the document of the National Archives, whichever direction that is, right nearby here, right? The reason why it's it and not something that you would create is because it and only it went through that unique process. Right, and actually thinking about, I was just over in Hungary and thinking about their constitution as a counterexample, right? One of the challenges they face is they don't have a founding moment. They have a long unwritten constitutional history for over 1,000 years, like the English. Then they have the communist interregnum, and then they have had kind of like versions of a constitution that has evolved over time. And so it's hard for them because it's hard, I think, to do originalism over there. I think impossible because they don't have a discrete text at a discrete time that they can use it as the sole tool. They can use lots of other tools as well. If I may say just one thing, I would be interested to hear, so one of my favorite areas is the Commerce Clause. And I think of the Commerce Clause as being almost utterly determinatio all the way down. And I'd love to hear what Professor Arcus has to say as to how his theory of interpretation, if any, maybe the answer is none, would change from an originalist interpretation, because I think of it as an area where there's not a natural law norm. What should the national government do over interstate commerce? I mean, I think there's reasons, but they're entirely contextual reasons based on the country, based on the time. And I think the case law, I think Thomas's opinion, Lopez, his concurrence is still the best one on the original meaning of the Interstate Commerce Clause. I think that adequately captures that constitutional meaning. And so what would your approach do differently, if anything, in that context?
But by the way, it's just, no, I thought, decidedly, I thought you had a deeper argument on ratification, because I thought you were saying that it was important that this was done by conventions, different from legislatures, to establish the meaning of the meaning of the Constitution. Is that right?
I think I would say no.
Oh,
The reason why I think it's important is because you had two bodies that were drafting a text, and so you couldn't use a non-public meaning for both bodies to understand what it was that they were drafting and authorizing. There had to be something that was accessible by both bodies in order for there to be interpersonal communication. So maybe that's what you're referencing. So I do think it's
no.
important.
I thought you were a little deeper.
Yeah.
On the Commerce Clause, I'm with you. I'm with the original thing. Once I gave a talk before the Supreme Court Historical Society years ago on the New Deal and taking the old line. We're calling Wickard versus Filburn. Remember Wickard versus?
I do remember.
Yeah. And
I'm worried about it with your jurisprudence, honestly. Like that's what I see.
oh no! I said, we thought we could give these arguments about the Commerce Clause, but all we had to do was show that anything we do runs counter to the right to abortion, and people would discern these things. So I offer this with Frank was there, that let's try Wickard versus Filburn about abortion. That private abortion may be yours alone, but when it's connected to 1.3 million abortions every year, it's having the most profound effect on the interstate sale of baby food, diapers, bassinets, bar mitzvahs, college educations, to say nothing of 1.3 million people coming online every year. You have to support the welfare system. We could use Wickard versus Filburn to strike against abortion, sure. And the chiefs, Michael Lehman said the chief's eyes were dancing when I did that. But I like Clarence has been good on that. The Commerce Clause is really understood, I think, is the most important.
So is there an area where you would say originals have identified the original meaning being X, but your jurisprudence would be not X?
No, I think it's most of the time. I would think so most of the time. I haven't. No, it's. That's a good question. I think I taught the American founding. I think there is a good case for doing things as we did there, and we could give reasons for it. Just as in Hamilton in 33, he could show you that the necessary proper clause would be there even if it weren't there. It's the logical implication of a moral agent reflecting on the rightful ends of his powers, and the supremacy clause would be there even if we didn't make it explicit. And of course, remember James Wilson and Alvin also didn't want to put in ex post facto clause. It's so obvious, everybody knows it. We'll just embarrass us by putting that in. So again, I think it's I don't think those people, as looking back at them, were embarrassed by the notion that they really had to go back to those principles they were drawing on the first. They didn't see anything discordant there.
Well, I'm sort of wondering, picking up on that point in an exchange you had earlier, is everyone doing natural law to some extent already? If originalists are looking to founding era record, which is drawing on the English historical record, which is picking up on reasoning all the way back to the 12 tables, at some point are these principles so infused in their interpretation of the positive law that they are in fact doing what we would call natural law determination under another name. I took that to be sort of your point regarding the Heller concurrences and perhaps other decisions, that maybe it hasn't been labeled as such by the judge, maybe it hasn't been identified yet by the theorists, but that's what's happening anyway. Does that in part account for the symmetry between the approach of the natural law theorist and the original?
I guess I think the answer is no. So whenever I do events like this, I try to reread the Constitution, right? So you see the two-pager. And when I look through it, there are not many propositions in there that strike me as being determinatio, but not having additional ethical valence beyond whether they work well or work poorly in a particular legal system. So I think with some exceptions, right? So I think that due process. There are reasons why due process evolved in the Anglo-American legal system. There are sound reasons why it evolved about treating people well, treating people with respect as reasoning individuals. But I gave the example of the post roads. You can imagine many, many other examples. Or thinking of executive power, which is in the news a lot recently. Our conception of executive power derives a lot from the English monarch. And that's not because the English folks were sitting around thinking great thoughts about natural law. It was these had worked well or this had worked poorly over time. And so I think most of it's determinatio almost all the way down, which works well and therefore is securing the goods that allow us to flourish.
You just recapitulate Jonathan Gineb on the Myers case, where Chief Justice Taft invoked the powers of the monarch, the British monarch, to explain the executive power. And McReynolds came back and said, "Oh no, there's a lot of resistance to the British monarch as the source of all this." No, look, on this matter of determinatio. Look, we're clear. We're talking about the ground of the Constitution. As we recognize, consistent with natural law, you can have a variety of constitutions, right? And show that. So I say, no, we're talking about structure. There are things in structure I've got to know about. I want to know whether a state may make its territory available as a military and naval base for another country. I want to know who the army will obey if the president dies in office. I want to know if there are going to be elections every 2 and 4 years in this country, even in wartime. I've got to know things like that. Quite apart from the underlying principles of natural law, we need those elements of structure. So there's no inconsistency there, I think, Lee.
I think I agree. So how do you explain this, Professor Arcus? Maybe you've changed.
Okay.
In 1990, here's what he said. Judicial review, quote, must encompass the question of whether the restrictions or penalties imposed by the legislation can be substantively justified.
Who said that?
You said that. and so I guess I'd love to see which part of the Constitution's original meaning supports.
May I hear that one more time?
Yep.
I may want to set it to music.
It is elegant, yes. Judicial review must encompass the question of whether the restrictions or penalties imposed by the legislation can be substantively justified.
Right. Yeah.
Yeah. And it wasn't in the particular context of, a review under the free exercise clause or free speech. It was just a general, my reading of the context was a general judicial review power of the office that judge.
Yeah, well, it's plausible that whether it's, the judges may be very lenient. Do you think you're enough established to establish their legal blindness? Yeah, the lawyers for Roe versus Wade did an impressive brief to show that the unborn child has been nothing other than human for its first moments. It didn't take much for the court to say, yes, you've established a compelling enough ground in embryology, woven with the principle of reason. You show why, yeah, it is justified to cast protections of the law on those small human beings in the womb. Yeah, that's what I think judges should be doing. They should be reckoning, but in any case, whether this law was justified or unjustified.
So then I think we found some distance, Judge Mady.
Yeah.
What you mean the point, whether it simply passed in a legal way? Oh, you mean so we accept the reasoning of Buck versus Bill, huh? It was passed by a legislature of reasonable men.
So if the argument is that a theory of interpretation that doesn't lead to uniformly perfect results is therefore a bad theory of
It doesn't have to be
interpretation.
uniformly perfect. plausible, defensible, but as plausible as reasonable people are considered. What's a justification for making people drive in one lane rather than another? You know.
All right, so since some of it has failed, we are going to try. And, time being short, but I do want to turn this over to the true jury on this issue, and open the floor up to questions. I see one
Yeah,
on the
I'm
left.
just gonna try to posit maybe one way of squaring the circle. So I think that one of the difficult things of talking about the founding generation is you have folks like Jefferson wearing many different hats, right? So Jefferson serving as ambassador, looking back at the Whiskey Rebellion, saying it's wonderful that the rule of law is breaking down, that there's a threat to the Republic, and that this should enshrine our rights. This is a great thing, talking about natural law in that way. It's not in the same way in the sense that Jefferson, the president, acts or necessarily speaks. So I'm wondering, maybe one way of squaring this circle is thinking of it this way, that natural law jurisprudence is a perfectly appropriate method to employ constitutional creation and a justification. But as a matter of jurisprudence, it's not necessarily an appropriate method and kind of diminishes as we recede away from that founding generation.
I think it's simply as a means of giving the most coherent account of the judgment you're making. That's all. That's all. It's no mysterious language. It's not a theory hovering in the sky. As I used to say, to ask whether a judge can get through the day without falling back upon the moral reason of natural law is like asking the question, can I order the coffee without using syntax? It's there. It's woven into everything you're doing. The problem is you're not noticing it because it's just part of the natural apparatus that you've been using all this time.
I think I agree. I think I understand what you're saying, and I think I agree with what you're saying. I guess what I would say is that there's the justification question, which is what you were describing, and then I think it's a separate question. So we've got a legal regime. Do we have sound reasons to follow? That's the justification question. I think we're on the same page, Professor Arcus and myself. And then there's a separate question, which my claim is a legal question itself, which is how does one operating in the legal system operate? How do you exercise his or her legal authority? And for that, I would need historical or legal evidence of that. And I try to provide just a smidgen of it. The other book that I would read it for what it's worth is Jonathan O'Neill's book, Originalism in American Law and Politics, which is I'd say a more updated version of the Wolf book that I had suggested earlier. So I think it's really just an empirical question, what our legal system chose, and then we find out what the law says.
It's just like, oh, I'm sorry, here's a question. I was going to say something.
As a matter of history and precedent, you raised Fletcher v. Peck as an example, but it seems like in Trustees of Dartmouth v. Woodward that Marshall sort of conspicuously rejects a natural law reasoning, and then in the Antelope, which is about a maritime case 9 years after that, Marshall explicitly rejects
Oh, yeah, that was a bad one. That was a bad one.
It was a bad one, but it's nonetheless a significant precedent. Do you think that, I mean, how do you make of that transition over an 18-year span?
Well, as Mr. Strauss used to say, Your Excellency, not always. But Dartmouth College, what's the problem with Dartmouth College?
I don't have a problem with it. It's just, it seems to be a parallel to Fletcher that very conspicuously avoids any natural law.
Well, I don't know. He says, look, it could be that, for example, Amherst College might be an even better literary project if you have John Updike and all these other people. But as Marshall said, yeah, it could be a better literary enterprise if they had all these great authors, but it wouldn't be theirs. It wouldn't be the one they founded, this private entity directed to the ends of the. No, I thought it was. I still think it was a pretty good opinion. The one thing. Just wait. This ordinary play. Just take an ordinary case. Rhode Island versus Innis. The cops get this guy. He's got a sawed-off shotgun, and they have him in the car. And the cops say, there are kids who play here. And some of them may found this, and the guy said, wait, I'll tell you where it is. Brennan and Thurgood Marshall say, this is unwarranted. You appealed to his good instincts. So it's unfair to appeal to his natural instincts to avoid it. And so in other words, they had in mind Hobson man, who has no interest beyond his own self-preservation. And if you lure him away by trying to get him to be concerned for the safety of those other kids, you're doing something contrary to our constitutional process. Our judges thought, no, it was perfectly reasonable that you would appeal. Now, I say that's a very innocent thing. But in that thing, they're saying, well, no, it's very plausible to appeal to someone's natural sense of concern for children. Nothing wrong with that. They weren't using natural law. But in those cases like that, we can show many cases where people doing things like that. Or my friend Scalia, I tell him, for a guy who always rails against natural law, you keep giving handsome examples of how it can be done. What's the case with the use of drugs to advance suicide?
Gonzalez versus Ridge.
Which one? This one? No, it wasn't Ray, because the Oregon case. I think.
Ashcroft versus Oregon.
Okay, so Nino's taking the line. No, there's a reason for drugs. Drugs to be used for the health and restoration of the patient. Kennedy says, well, that's one interesting view. And Scalia just about does a Minuteman 3. One interesting view. It is the only natural view. Natural. You mean not natural like this. You mean reasonable? Reasonable? Yeah.
I think Dartmouth actually supports my position for what it's worth. So I see Dartmouth College. So here's the contract, right?
Let me hear it.
Yeah, so Article 1 says impairing a contract, and so the purported contract is an articles of incorporation by a state. That's a stretch under the conventional meaning at that time. And Marshall was reluctant to say, like he did in Fletcher versus Peck, right? He was reluctant to add on the window dressing of some kind of normative justification. So I think that's the normal MO for Marshall, where he's bending, pulling. I think he maybe went a little bit too far there. I think that was a misinterpretation. But his inability to publicly say, I think this is wrong, and therefore I'm going to rule because of the wrongness, I think supports the evidence that the legal system at that time period proscribed federal judges from utilizing natural law as in their justifications.
You don't disagree with the judgment in Dartmouth College?
I do.
You do?
Yeah.
Well, as Scalia would say, let me think about that one.
I think we could squeeze in one more question.
Would this evening have been the same if we were debating empiricism versus rationalism?
Debating what?
Empiricism versus rationalism.
How would you define those terms if it's all right?
Empiricism, maybe looking through experience and tradition, and rationalism is using, as you said, Professor, the syllogisms and tautologies, abstractions.
I guess I view originalism properly understood as utilizing all sources of human knowledge. And so we would use our logical faculties to create arguments for or against propositions. We would use empirical evidence to support or undermine propositions regarding what the original meaning is or is not. So I guess, and even the natural justification as I see it is logical, but also rationally informed regarding what it is that we human beings pursue and find truly good and flourishing, and those things that we don't.
No, I don't think so. Except maybe I might be sensitive to one kind of wrinkle, or I see some people arguing that what is good about originalism is that it leads to a better flourishing of human life. That's an empirical claim.
Mm-hmm.
That's an empirical claim. Yeah. It's whether it is or not is depends on the outcome. That's not a moral claim. I want to be sensitive when people are confusing these predictions, the speculations they're making, from something that has the solidity of a moral claim.
Yeah, that's true.
Okay.
Last one question.
I'm going to try to do the Jeopardy rule and make a statement in the form of a question. Because Professor Strang, you said something that I hadn't thought of this question before. You said that, to restate it, Hadley thinks about the first two parts of Aquinas' two-part steps, and you think, and would like to think of the second two steps. My argument back is the second two steps don't make sense without the first two steps equally weighted. Maybe that doesn't contradict you so far. But maybe there's a clue in that enigmatic statement in Corwin's book, where he says before it could be natural law, it had to be positive law in the strictest sense, meaning argued out and discovered. Remember, classical political philosophy, natural law tradition begins in discovering nature, which is a process of reason. Okay, the empiricism question. If you've looked at it with, to my mind, horror at philosophy these days, academic philosophy, it's becoming empirical. and mathematical. They use algebraic notation, and so it's unreadable to an ordinary human being. Law has never done that at all. Law cannot escape what Hadley was saying at the beginning about the necessity of language and the meaning of language. And so here I sort of want to make a challenge and a suggestion, and I can go on, but I'll stop. Otherwise, I'll invoke Harry and we're in big trouble. But so I teach political science and political philosophy, and if I could do one thing, wave a magic wand and do one thing, it would be to ban forever the use of the word normative. You're not isolated. We have lots of company. The point is that if you try to put way it's used today, not just in law, but in political science, social science, it reminds me of the algebraic problem you get to in advanced functions. You have the f of x. So normative becomes the x now, except we have become, I think, sort of philosophically illiterate and then playing out the x that drives us all crazy when we do functions a million years ago. So here's the problem is that if you, and now it goes back to the beginning, if you get those first two steps, the second two steps don't make any sense, and that's why.
So why should we say, what are the first two steps that explain the third?
Well, it's the self-evident, what is the nature of a self-evident truth? You stated part of it, right? It's
Well, it's ordinance of reason for the common good,
Right.
the Aquinas definition.
right. And I forget them too.
And then promulgated, is what you're talking about the Aquinas definition?
Yes, right.
Yeah, and then promulgated by him who has carried the conversation.
Complicated and the person who's got the right, the
I
responsibility.
didn't take your argument to mean that you were separating the four principles, so.
I was saying that the argument that as I heard so far was missing two key elements. And I didn't present much on the first two key elements, which I think maybe Professor Hayward, you're referencing,
Yeah.
totally appropriate. But it's easy to identify what they are from my perspective, right? Which is, so what's the ordinance of reason the Commerce Clause, his original meaning has? It's Congress has the power to regulate the commercial transportation of goods and services across state lines. Ordinance of reason. Now, it's when you say ordinance of reason, what do we mean by that? We mean deep determinatio, right? And so it's an ordinance of reason for our political community. And then is it for the common good? So I think that's a prudential judgment that the framers and ratifiers made in 1787, 89 to identify how to overcome the trade wars that were going on in the states prior to that time.
Right, but see, I assume, Lee, that you were folding in the first couple of steps, because the question is, who is it who has the authority to promulgate them? See, remember, once, so I assume, remember, I was once at a meeting with that professor from Notre Dame, Amy Coney Barrett, and somebody said, why do you have this reference for the positive law? What makes the positive law in America higher than the positive law in Stalin's Russia? See, we could give an account there. Okay, but I assume you were folding that in. You assume that it matters. Yeah, it matters as to how we get to the person who has the authority to promulgate the law.
I guess I'm sorry, I don't see myself folding. I see that I emphasize the latter two in your remarks because I thought I was going to distinguish us, but I don't mean to, and I definitely spent a lot of time identifying the ways in which the first two.
But you think it must profoundly matters to the grounds on which you establish the authority to promulgate the positive law, right? It can't be simply he has the power to do it.
I think it's a little bit complicated. I would say there are two ways to look at it. One is an internal perspective. So in our legal system, how do we know what the supreme law is? And that's going to vary based on legal system. In America, it's framers and ratifiers. They adopted the thing in the National Archives. But then there's also another perspective, which is, and do we have sound reasons to follow it? Right. And so I think you're focusing on that latter part, which is true and good. And one needs to have an answer to that question. So you can have a legal system that is unjust, right? That you don't have sound reasons, but you know that there's law in that jurisdiction. It's just wicked law. But you could also have, in the full flourishing version, this is the idea of all four aspects of Aquinas' definition are met. You have law that's recognized by the legal system. Everybody recognizes that this is our law, and there are sound reasons to follow it because it secures the common good.
Well, sounds appealing to me, as you put it. It's like, as this question came up, and Amy Barrett was kind of stuck with the question, it was it is a string of three questions from Locke. Locke says, what is the source of the law? The legislature that makes the law. Then he asks, what is the source of the legislature? Well, Constitution, that's why they have a legislature. But then Locke asks, but what is the source of the Constitution? It must be some source wholly antecedent to the positive law. In our case, it was no man is by nature the rule of other men, the way that men are by nature the rule of dogs and horses. My dear friend Scalia said, that's lovely, but no one enacted it. And the answer was, No, it couldn't have been enacted because that had to be there in principle before we knew who had the authority to enact anything. Lincoln gives us powerful argument in the inaugural address. That rule of the majority under moral and legal restraints is the operational form of rule by the consent of the governed. But he takes rule by the governed by the consent of the governed as the principle.
Judge, is there a
He
settlement?
got the first word, you.
Oh, I just want to ask, is there a settlement or not?
Is that what?
Is there a settlement?
What there is the best of conversation.
Okay.
I'm with you, I'm with you.
When our host opened this up tonight, he promised a blockbuster engagement. I have to tell you, I was wondering if that was overselling. If anything, it was an understatement. This rich conversation, like all great ones, has to end before it's settled. But I want to thank both of you for this
Thank you all for
engaging
coming.
discussion. And I want to thank our hosts for the generous opportunity.
I was at an awards ceremony, well, where one of the awardees said, I asked my wife, darling, in your wildest imagination, did you ever dream I could get an award of this kind? She said, darling, I don't know quite how to tell you this, but you're not in my wildest dreams. Well, no, you're not either, but thanks for coming tonight.
We are in charge. Thanks, everyone.
What an honor to have you.